Got it. Thanks, James. Good afternoon. My name is Christopher Brown. I'm from NorthStar Law Group. We have offices in Olympia and Seattle. I'm here in Olympia at my office close to the courthouse right now giving this presentation. Last year, James asked me to present on just basic legal structures for just small business in general. And some of the conversation today or presentation today will actually be drawing from that presentation, because most of the formalities that getting into a legal structure are the same, although there are some huge differences when it relates to professional businesses. So I'm going to go ahead and pop up my share screen. All right, and then we have, here we go. All right, so we have ScaleUp Mastermind legal structure for professional service businesses. So before I begin, I need to give a disclaimer. Basically, the information, basically it says that the information I provide cannot be relied on for legal advice because you are not my clients. So this is just for general informational purposes only. If you decide to move forward with engaging in some sort of setting up a legal structure based on this presentation, I highly advise you to seek legal counsel. And the views that I present are solely mine, and they are not those of NorthStar Law Group. It's basically me and not the law offer. So that's it in a nutshell. So let's get started. So choice of business entity, I'm assuming that based on what James told me that you've already kind of established your business and you're ready to take the next step. So when we think about what type of legal structure for your business, we kind of go into three different things. One, how easy is it to use? Because certain business structures are pretty easy. Some are much more complex. It's a matter of just how much of an effort that you want to make outside of what you're doing professionally, or what things that you need to do to make sure that you need to be successful. And do you want it to be easy, or do you want it to be more difficult? And there are some reasons why those things are more difficult. Number two is risk exposure. I mean, how risky is the business that you're operating in? How much liability exposure do you have personally, as well as professionally? I mean, maybe a person that's in the practice of acupuncture has a lot less liability exposure than a CPA. So that's a consideration that we need to take into, is basically industry risk. And then basically also, how risk averse are you? Are you kind of okay with this basically flying by on your malpractice or professional liability insurance, or you want something much more robust that will protect you in other instances as well? And lastly, we talk about tax structure. Do the owners of the business entity, do they need flexibility in how they structure their tax situation? If you're to do a corporation, a professional service corporation, do they qualify, to be an S corporation? Because there are certain qualifications to be an S corporation shareholder, and if you don't qualify, then you can't be one. And lastly, do the owners want self-employment tax savings? That's usually a huge issue, especially when we talk about the difference between partnership taxation and S corporation taxation. That's one of the major considerations as far as making that jump from one tax structure to a subchapter S corporation. So first off, I'm assuming that if you haven't set up a business entity already, then you're probably a sole proprietorship. And they are really easy to set up. Basically, you're it. I mean, you don't have to do anything. All you don't have to register with the Secretary of State's office. You only need to really get a business license, and that's usually filing an application with the Department of Revenue, their business licensing service, as well as the city that you're operating out of. And if you're in an unincorporated area, then you don't need to worry about that either. But really, all you need to do is register with the state to get your business license application sent into the Department of Revenue. You don't need any operating documents. Like, for example, if you're an LLC, you don't need an operating agreement to describe the structure of the business, the duties of the owners or management, all those other things, because again, you're it. Basically, you don't have to write anything down. There are no corporate formalities. You don't need to have meetings. And frankly, if you're sole proprietor, how are you going to have a meeting with yourself? You'll need to have that, and you also do need to file a separate federal income tax return because you're not a legal entity. All of your earnings are reported on your, your individual tax return, your 1040 every year, Schedule C, usually. Downside of a sole proprietorship is there is no liability protection. You would basically, if you get sued for what you do in your profession, then you, outside of your malpractice insurance or professional liability insurance, whatever you call it, you have no legal protection. So if a client or customer of yours sues you personally, then they can go after all of your personal assets that the insurance coverage doesn't cover. So that's a huge consideration. And that's why I'm, my highest recommendation is if you are in a profession, I don't care what it is, get set up a professional business legal entity, and for lack of a better term, I'm calling them PBLEs. That's not a defined term. That's something I just came up with. The reason to do that is to get liability protection over and above your liability insurance coverage. In addition to professional liability insurance, I also highly recommend getting a business insurance. That's just basically a standard protocol. And as sole proprietors, actually, a lot of them do get just basically business insurance in the event to protect their assets and things like that. Now, I don't know if you've seen the movie The Incredibles. It's one of my favorite Pixar movies. And if you recall that, once the Incredibles have been kind of outed and basically let go from the responsibilities, Mr. Parr here, the superhero, he becomes an insurance agent. And here he is talking to this little lady saying, no, ma'am, we can't cover that, and things like that. In the meantime, he's trying to teach her how to go through all the labyrinth of rules and regulations to actually get coverage on her account. But then once he's found out by his boss on the right, the boss says, we don't care about our clients, we care about our customers. And that's probably the downside of business insurance, because insurance policies, the companies have a way of not paying if they don't have to. It's really dependent on the language in your policy. So that's why, in addition to getting business insurance, I highly recommend setting up a legal entity, provide that additional protection that you can't or may not get under your business insurance policy. What's the importance of business liability protection in a legal entity? What it does is it reduces or eliminates the exposure of your personal assets to liabilities or claims of the business. For example, if the business, your whatever you do is either you get sued for breach of contract, negligence, whatever, if provided that you're operating the entity correctly, the owner's personal assets should be protected. That's what the liability entity does. Limited liability entity does. Now, again, this is all contingent on making sure that you operate correctly. On the flip side, if, say, for example, it also reduces or eliminates the exposure of your business assets to the claims against the owner. So if the owner gets in a car accident and gets sued by the other person, then the business assets, equipment, accounts receivable, et cetera, should be protected as well. So it works both ways. That liability shield between yourself personally and the limited liability entity. It's important. The business must be operated separately from the owner. You do not know how many times I've seen people come to see me and say that, oh yes, I've been paying for my groceries using my business account. That's not how it works. Basically, your business should be paying for your business assets, and your personal accounts should be paying for your groceries and things like that. Do not commingle your assets. Sign business contracts as the owner, president, manager, things like that. As you have a title, when you set up a business entity, sign in that capacity. Do not sign in your own name without that, because again, that shows that you're not treating the entity like it should be. Document everything. I know we're trying to go into a paperless society, but in this case, paper helps. If you make a business decision, write it down. Make sure it's documented. Again, it shows evidence that you're treating your business as separate from yourself. Again, if you have a business partner, hold business meetings and document them as well. Now, when you're entering into contracts, just sometimes your vendors or whomever your banks may require, personal guarantees on, from you in lieu of the business. We try to avoid those, but unfortunately, sometimes those just kind of come up because that's just the nature of the business or cost of doing business. But just make sure that, again, keep your separate, business separate from yourself. And lastly, make sure that the entity is properly capitalized, that it has enough assets in it, cash in the bank account, equipment, things like that, to operate as a business. Do not treat it as a shell business, has nothing in it, maybe just $100 a separate bank account. Make sure it actually has assets in it. Otherwise, creditors could go after that business entity and shoot right through it and go after you because you're not treating the business separately from yourself. So, with setting up a business entity, a limited liability entity, they're great, but there are some, rules and requirements to make sure that you're actually properly operating it. Now, for professional business legal entities, there are three options in Washington. You have a professional limited liability company, which is PLLC. You have a professional service corporation, which is what NorthStar Law Group is. It's either identified as a PS or a PC. PCs are relatively new. They have them in Oregon, but they brought the term up from Oregon to Washington. And we have a limited liability partnership. Limited liability partnerships, at least in my practice, are very rare. So I'm not going to talk about them too much. But I will cover them only because they are another option that is out there for you. So which professions can form a professional business legal entity? Any profession which requires licensure or other legal authorization with the state. Chiropractors, dentists, osteopaths, MDs, veterinarians, architects, engineers, attorneys, and there are others as well. I didn't want to go through the entire list because it's very, very broad. Now, all owners of the entity must be licensed in the profession for which they formed the entity. So if you have 5 different owners of a PLLC, all 5 owners must be licensed in the state of Washington in the profession for which they're performing their services. There's no out of that. So you can have an outside investor being an owner of your PLLC or professional service corporation. Every owner has to be licensed in the profession for which they perform their services. Now, again, like I said, all owners must be licensed in the profession for which they're performing the entity. It's normally the same profession. Me and my partner Ruth, we are both attorneys. Now, there are some exceptions to the rule. Physical therapists, occupational therapists, they can actually form one PBLE. Their clientele is different, but what they do is generally the same. So basically, the state law allows for that. Massage therapists, acupuncturists, dietitians, and certain other health practitioners may form one PBLE. I like to think of these as more the holistic, healthcare practice, like East Asian medicine, things like that. Things are basically not really that go to the level of MDs, but they do provide some healthcare benefits for their clientele, and they are required to license. Those professionals can combine to form one PBLE. And engineers and architects, they create one PBLE. They're both in the industry of construction, generally. They're building stuff, they're designing stuff, and then they're building stuff. So that kind of makes sense, that they could actually combine to form a professional business legal entity. Now, granted, I wish I could form a PBLE with the CPAs. I love CPAs and I work with them often, but unfortunately, state law doesn't allow that. But for certain industries, then you are allowed to kind of go outside of your particular niche profession and combine with others. Liability protection for professional business legal entities. A PBLE will provide liability protection for its owners from third-party claims against the entity. So if somebody outside of the entity sues the entity, it will protect all the owners from that liability, mostly for breach of contract or things that are not normally associated with actually the services that are provided. So again, you basically don't pay on a bill to a vendor, and the vendor sues the entity. That entity, that PBLE, provided it's operated correctly, will protect its owners from personal liability from the claim against the entity. However, it will not shield an owner practitioner from a malpractice claim brought against that owner. So if you have 3 doctors within a PBLE and a claim of malpractice or other breach of their professionalism, a claim is made against that one owner, that owner will not be shielded by the PBLE. That's still out there. Now, that being said, it will shield the other owners from that claim brought against the quote offending owner. Now, for professional services corporations and PLCs, that owner practitioner rule also applies to the liability of those directly under that owner's control. So if you have like a secretary or maybe a assistant helping you in yours providing the services, and they commit a malpractice claim, and that person is under your direct control because you dictate how those services are provided, then that owner is subject to the claims of malpractice as well. Now, that doesn't apply to LLPs, strangely enough, and I don't know why, and I didn't really care to know, but why. But it only applies to professional service corporations and PLCs. Now, for malpractice, under certain provisions, a PLC or an LLP, they must maintain malpractice or professional liability insurance policies on itself and its member owners of $1 million, at least $1 million, and it could be more if the profession requires it. Now, if there is an insurance coverage and they require amounts, then the company's other members could be personally liable to the extent that there's that gap in insurance coverage for that offending practitioner. And I have an example here. A group of 3 dentists has a malpractice policy with only $500,000 of coverage for its members and its and the PLC. If one of the members is sued and is held liable for $1 million of damages, and the claimant wins, all the other members are jointly and severally, which means everybody individually could be personally liable to cover that difference, that gap in coverage. So, and that applies for PLCs or LLPs, and doesn't apply to professional service corporations. That's strangely, the statutes are silent on that, and I don't quite understand why, but those are the rules. Now, that being said, if you are a licensed professional, I'm sure that you have your own malpractice insurance requirements that are kind of espoused by your various boards as far as what type of liability insurance that you must have anyway. So basically the professional service corporation rules kind of require that. So, but there isn't a hard floor of $1 million. Okay. Looks like my thing died. Oh, there we go. Now, here's what goes into professional limited liability company. For ownership of a professional limited liability company, you can have one owner or can have more than one owner, and they're known as members. Before I formed NorthStar Law Group, I was on my own, so I had a PLC, and I was just myself, one owner. Management. How is the company operated? It can be managed by a manager or the members. In a manager-managed LLC, the manager has the actual authority to bind the company in a contract. So if you're buying a printer, you have a printer service, a copier service, the manager has the authority to bind the entity to that contract. The manager is like the day-to-day operations person. In a member-managed LLC, any member can bind the PLC in a contract. So if we have 5 members in a PLC, and one of the members who doesn't really do anything, but they go out and buy a car in the name of the PLC, visit clients or patients, doesn't let anybody else know, and then the company is bound by that contract. Of course, this is absent any actual knowledge by the car dealership that particular member doesn't have the requisite authority to do that. And that's kind of one of the downsides of limited liability company law in Washington. I brought this up in my presentation last year, which is why I'm not particularly happy with LLC law, the default rules, because unfortunately, nothing in they got rid of the requirement that the certificate of formation, the document that you file with the Washington Secretary of State, as to determine whether the LLC is manager managed or member managed. So that puts the onus on the third party vendor to figure that part out. If who has the authority to enter into contract with the LLC. So at least in my certificates of formation for LLCs and PLCs, I always say that in that document, this LLC is manager managed. Because I like manager managed LLCs. We have one person that's actually the front person to bind the LLC in any contract. And if I put that into a form that's filed with the Secretary of State, then anybody dealing with the LLC can actually go online, get a copy of that certificate of formation, actually know who has the authority to bind the LLC. Now, for tax purposes, if there's one owner, a single member LLC, they're most likely treated like a sole proprietorship. Don't need to file a separate tax return. And again, when I was a PLC, I didn't file a separate tax return. I just filed everything on my 1040. That's kind of nice. I don't have to pay a CPA to prepare my tax returns, things like that. Now, if there's more than one owner, a PLC is generally taxed as a partnership. One level of tax at the partner member level, everything that flows through the entity. The entity itself doesn't have any tax at itself. All the income, losses, deductions flow through to the partners. Generally in accordance with their ownership in the LLC or the PLC. But that can be changed too, depending, and I'll get into that a little bit later. However, you can elect to be taxed as a corporation. There are certain elections that you can make that allow you either as a single member of PLC or a multiple member PLC, make an election that, hey, I want to be taxed as a corporation, whether it be a subchapter S corporation or a subchapter C corporation. 99.9% of the time, you will elect to be taxed as a subchapter S corporation, for reasons I'll get into a little bit later. Okay, my clicker isn't working, so professional service corporations. They also could have one owner, one shareholder, or they can have more than one shareholder. Now, the structure of a PS or PC is like a regular corporation. There's 3 levels of management. The first one's the shareholders, the owners. They are the ones that get all the profits or distributions from the entity. And their role basically is to elect capable directors that will make a profit for the entity. Under Washington state law, all the shareholders has to be licensed in that particular profession. And so again, they elect the directors, and then the next level, the directors. What their role is, they're the vision people. I like to say that they think globally. This is what we see the corporation being now, and this is what we want it to be in the future. They're the big picture people. So they develop the game plan, and they sign off on the bigger decisions, and then they elect the officers to actually execute their vision. And again, under Washington law, everybody has to be licensed in that particular profession. And the third role are the officers, president, vice president, if you want to, secretary and treasurer. Under state law, you're required to have a president and a secretary. You don't have to have the other ones, but generally, I do like having the treasurer as well. They're the people that actually execute the vision, and they are the day-to-day people. They sign the checks, they sign the contracts. They're the doers. Now, the president, vice president, most other roles in the entity, all those people, those officers must be licensed in the profession. Now, the secretary and treasurer, they don't have to be. So I have a client that's actually in a profession, and he has his wife who is not licensed as the secretary and treasurer, frankly, because he doesn't have the time to sign the checks. and kind of go over the bills and things like that. She's not licensed in the profession, but state law allows for that. Taxation could either be taxed as a subchapter S corporation, and a subchapter S corporation, there's only one level of tax, like a partnership. It's at it's shareholder level. So all the income, losses, deductions, things like that, they flow through the entity, and they go to the shareholders in direct proportion to their ownership in the entity. Or you could be a subchapter C corporation. Unfortunately, with the subchapter C corporation, those are basically your Microsoft's big corporations, Amazon, or they could be startups too. In tech, they may elect to be subchapter C corporations for bigger tax savings when they sell their stock after 5 years. And that's a different conversation for a different day. But again, for professionals and most people, the doers, if they want to get subchapter elect to be a corporation, taxed as a corporation, they are almost always subchapter S corporations. And now it doesn't matter how many shareholders you have; it could be one shareholder in a PS or PC, or many shareholders in a PS or PC. You still need to file a corporation tax return, so you can't get out of that. Unlike a single member PLC, where you don't have to do that. Limited liability partnerships, ownership must have 2 or more owners. You're partners. You can't be a partner with yourself. So it has to be 2 or more owners in a LLP. Each partner is a managerial agent of the partnership. So each partner can bind the partnership in any contract. Again, that's the default rule. But if third parties know that a partner does not have authority to act on behalf of the LP, then the contract is voidable. And again, if you want to actually restrict a particular partner from having authority to sign on behalf of the company, it's usually recommended that you put that into your certificate of limited liability partnership when you form the company. Taxation, they're taxed as a partnership. Although they can elect to be taxed as a subchapter S corporation, although there may be reasons against that, just for allocation of profits, losses, things like that. Oh, went too far, sorry. Income, and then we go back. Yeah, there. Income taxation. For a second.
It never fails, does it, Chris?
Never fails. Well, unfortunately.
We can't get away from the technology.
No, unfortunately, we can. So let's see if we find it. Practice. It is what it is. Oh, there we go.
Yep.
Income taxation. All right. So single member LLCs, they're treated as sole proprietorships. So all tax affecting items, that's what we call them, all the income, all the losses, if the business is generating losses, all the deductions, they flow through directly to the owner and report on the 1040s. Multi-member PLCs or LLPs, they're taxed as partnerships. So there's no entity level tax, and all tax affecting items flow through to the partners directly in accordance with their capital accounts. Now that's not necessarily ownership, it's basically capital accounts are kind of book items that reflect how much capital is put into by each member, or in this case, and then may not necessarily reflect ownership, because you could actually contract out of that. That's normally reflected by your capital accounts, but they can be. But that allocation of profits and losses can be adjusted if provided that you follow certain rules as determined by the Internal Revenue Code. So, for example, you may have a 50-50 partnership or a PLC ownership, but maybe 1 year you may want to allocate 90% of the losses to one partner and 10% to the other member, because the member that's going to get 90% of the losses has huge gains from other activities outside of the business. sold a huge chunk of stock, for a huge gain. So maybe the partners agreed to, hey, for this year, we'll allocate 90% of the losses that we have from the business because we're not making any money. We're actually losing money on the whole thing. We'll allocate 90% of the losses to help offset that gain that you had on a huge sale of Microsoft stock. You can do that, although there are you have to follow certain rules and you eventually have to make that up eventually. So that way, ultimately, we'll come back to a 50-50 equilibrium. This is known as the economic effect, substantial economic effect test. Talk to your CPAs about that. So that's why partnerships in some instances can be beneficial because you have the ability to allocate profits losses depending on certain other items that might be in effect. Professional corporations or electing PLCs or LPs, again, taxed as a C corporation or S corporation, it could be, you could be taxed that way. Now, for S corporations, again, I said almost all corporations or electing PLCs or LPs, they almost always go to S corporation status because they're small and they don't want that double taxation. They have to flow all tax affecting items, income loss deductions have to flow in accordance with ownership. You cannot shift income around like that. Now, if you're worried about certain instances of taxation, maybe make a loan to the S corporation. Maybe that will help offset some of it. But if for whatever income is generated by the business, it has to flow in accordance with ownership. So just keep that in mind. Self-employment taxation. All of the owners of a PBLE are subject to self-employment tax on their shares of earnings of the entity. So basically, it's a combined 15.2% of self-employment tax from whatever income generated by or revenue generated by the PBLE. Again, your LLPs, your professionals, your PLCs, all the earnings are subject to self-employment taxes because basically you are you are performing services, and so basically you're self-employed. So the IRS will go after that. There is the exception, and which is why most everybody that feels like they're getting hit by the self-employment tax, they always try to go to the subchapter S corporation route. Shareholders of subchapter S corporation PLE are only subject to self-employment taxes on their income attributed to their employment by the corporation. Any distributions in excess of their salary is treated as a distribution to the shareholder and not subject to self-employment taxes. For example, now granted, the self-employment tax hit does get phased out at about $130,000 per year. But still, if you make less than that, then you want to elect subject to S corporation status. For example, if you decide that your salaries is basically $60,000 per year, and that's basically based on industry standards and comparables, but you're killing it this year, and you make $120,000 this year, your business makes $120,000 per year, you will only be subject to self-employment taxes on the first $60,000 of your salary. If the corporation makes a distribution of that excess $60,000 to you, of the 120, that is not subject to self-employment taxes. That's just basically deemed to be a distribution to you as a shareholder of the corporation. Which is why most small businesses like to be S corporation if they are actually doing very, very well. Again, the salary has to be reasonable because you can't pay yourself $1 and pay yourself $1 in salary and then you make $120,000. IRS doesn't like that very much, and there are cases out there that actually says that the IRS is like that way. So you have to make sure that your salary is reasonable in the eyes of the IRS. It's usually based on industry comparables to other similarly situated professionals, and the criteria is basically experience. How much experience do you have in your area? Where are you practicing? If you're practicing in Seattle versus practicing in Olympia, there can be a huge difference in what other practitioners make in those areas. So again, you have to do some market research to determine what a reasonable salary is. Once you decide which one, and again, I pointed out at the beginning of this program that I don't really work with LLPs because they're kind of a rarity. So frankly, if you were to ask for my advice as far as whether or not you should be a professional service corporation or a PLC, that really depends on what you do, at least in my opinion, what you do and what type of tax situation that you have. And so that's more of a conversation that we would need to have should you come see me or another attorney describing what you want to do. Again, LLPs are kind of a rarity. They are out there, but I mean, maybe done one or two, and in my 20 plus years of practicing. So, and the law is always changing. So I generally recommend a PLC or a professional service corporation. Now to form a PBLE, first thing you need to do is file with the Secretary of State. In the case of a professional service corporation, those are the articles of incorporation. For a PLC, it's a certificate of formation. And for an LLP, it's a certificate of limited liability partnership. All of those need to be filed with the Secretary of State to get started. For professional service PBLEs, you need to, in the name of the entity, you need to make sure that you have exactly what you are. I mean, if you're a PLC, put PLC at the end of the name. In the case of professional service corporation, put PS or PC at the end of the name. If you look at the bottom, you see NorthStar logo PS. That's my legal name, the firm's legal name. It can't be anything else. It has to be one of those. Or you can say, you can spell it out. It can be a professional limited liability company. That's fine. Or a professional service corporation. That's fine. Or put LLP at the end of the name. Must have one of those designations at the end of the name. Now, it could be any name. Again, NorthStar Law Group, that's just basically a name that my partner Ruth and I picked out because it works well in different languages. But for dental professional corporations or PLCs, they are required to have the personal name or names of the dentists in the name of the entity. I have a couple of dentist practitioners that are PSs, and their names are in the name of the entity as required by state law. Another thing, they require a statement of purpose. Describe what professional service you'll be performing. If you are, an architect, this PLC is, performing services in the area of architecture, or engineering, or dentistry, or law, or naturopathy. Define what the purpose of the entity is. So that way, third parties, the public knows what you do. The whole idea is not to hide the ball as far as what you're doing through your professional service corporation. The second thing you need to do when forming an entity is get your employer identification number. Usually what I do is, Google EIN, and then I get into the IRS online portal and fill out the form online. I usually get that within 5 minutes. And if you're doing it yourself, that's great. Now, I also require that, if I'm doing it on behalf of a client, I have to fill out a particular form that was known as SS4. That's the paper form to get the EIN. This is say that I have it on file, that the client authorized me to do it for them. But for me, it's usually just, again, it takes 5 minutes to get the EIN number because you will need to have that. The third thing you need to do is file a business license application with the Department of Revenue. State with the Department of Revenue, Business Licensing Service, and the city. A lot of the cities actually, what they're doing now is actually tying their application licensing process to the state. So there is actually a city addendum to the state application that you file. So for example, if you're in the city of Olympia, there's actually, what you do is you fill out a city addendum to the business license application for the state. Say, I'm operating out of the city of Olympia. They have certain questions, such as, are you operating out of your house? How much square footage do you have in your office? How much revenue do you anticipate making in the city of Olympia? And then you just attach that to your filing with the Department of Revenue, and you're fine. And each city has its own fee that you file. I believe Olympia is $50 per year. Now, unfortunately, some cities don't have to tie their application, their licensing procedure to the state. Tacoma doesn't. I have a client that actually has, has to file with the city of Tacoma, go down to City Hall, fill out the application and do it that way. So, but there's a list of cities that where you could, on the state's website, as far as which city you could actually use the state's system to apply for a city license. The fourth thing you need to do when you form an entity is prepare operating documents. For a PLC, it's known as an operating agreement, limited liability company agreement. For LLP, it's a partnership agreement. And for a corporation, it's bylaws and resolutions. Basically, the idea behind those is they define the terms of management, who has authority to act on behalf of the LLC or corporation or LLP. You need to have that. And unfortunately, it is kind of an arduous process, especially when you're just setting it up. But the reason is because on number 5, when you set up your bank account, you'll likely need to bring in all the information in items number 1 or 4 above. Banks are very, very picky about opening up bank business accounts if they don't have all the information. They'll definitely need to have the article of incorporation or whatever things you've documents you filed with the Secretary of State. They'll need an EIN number. They might, well, most actually now that it's becoming more likely that you'll need to have a business license, at least in process with the Department of Revenue. So the bank can check and see if you're actually getting your license. And they'll probably need to have operating documents, or at least something authorizing whomever setting up the bank account that they have the blessing of the other members, owners, to set up the bank account. And again, number 6, make sure that the PBLE is properly capitalized. Again, put enough assets to operate the business. And the reason is the failure to properly capitalize may result in piercing the entity veil and result in personal liability should a creditor, third-party creditor, go after you personally through the LLC. Operating documents that I alluded to in item number 4, I believe. Those documents, they lay out management, who has the authority to act on behalf of the PBLE. This is the owners. And I'm usually looking at LLCs, the members, or a manager. And in such case, in an operating agreement, how much authority does the manager have? You need to define the scope. Is there only up to a certain amount of contracts? Usually, they can only sign a contract up to the amount of $10,000. Anything more requires the approval of the members. $50,000. What can the manager do on behalf of the LLC that doesn't require owners' approval to do? You need to define that scope. Now, if you have more than one manager in an LLC, or maybe more than one director or officer, most likely a director, how do you break a deadlock? Those are 50-50, who breaks it? Do you bring a third party in? Do you go through dispute resolution? How do you break that deadlock? And then how do you remove a manager? What's the process? Say, for example, the manager is just not doing the job. How do you go about removing them? What happens if they're disabled? How do you determine disability? And disability is kind of a nebulous thing. I mean, is it physical? Is it mental, emotional, substance abuse? Again, there's certain criteria as far as how you remove somebody that's acting on the company's behalf. Fiduciary duties. In each of these entities, there's the duty of loyalty and the duty of care. Duty of loyalty means that, especially for like owners, you have to act on behalf of the entity over and above any other activity that you have. If you're like multiple entities that are doing the same thing, then you have to make sure that you are loyal to that particular business that you're operating for. The duty of care, basically make sure that you're actually operating the business correctly. You're not running into the ground. You're not committing malfeasance or things like that. Those are fiduciary duties. You can actually limit most of these duties. Say, for example, I have clients that have multiple real estate holdings in different LLCs. The duty of loyalty requires them to basically treat one over the other, but we waive that because they're, again, different areas, different things like that. So basically, we waive the duty of loyalty, but duty of care we don't really get rid of because it happens in intentional misconduct or knowing violation of the law, fraud, defrauding the company, defrauding other people. There's a duty of care that can't be waived. And indemnification. Indemnification is nice, and that's another reason why I like PBLEs, is because they allow the PBLE to indemnify an owner for claims brought against the owner for acts that are done through the LLC. For example, if somebody sues both the LLC and the owner, shareholder, or member, whatever, because that's likely what's going to happen, because unfortunately we're in a very litigious society. Why not? The shotgun approach to litigation. And while the claim is frivolous against the owner because we have this PBLE out there for breach of contract, to protect against those things, we're still going to get sued. And unfortunately, in order to defend the suit, you have to, spend money, hire an attorney, or pay court costs and things like that. What indemnification allows says that the PBLE will pay the owner back for those expenses incurred in defending the lawsuit brought against them. What that does is, and that's a requirement, and I put that in all of my documents. That's a requirement that the PBLE has to do, because the benefit of that is drains the PBLE of resources that the creditor can go after should they try to prevail against the entity. So, and again, all the money is in the PBLE. So, what if the entity is forced to pay the owner for a frivolous claim brought against the owner, doesn't make the entity that much better to go after. I mean, again, because that's just draining the PBLE of assets to satisfy a frivolous claim. So we put that in there, so it makes claims against the third-party owner less palatable for a third-party creditor to go after that owner. So why go after the owner if there's nothing there, and the LLC has to pay costs to the owner? So that's why we put those in language in there. After formation, this is I always require that you have employment agreements. You need those for both the owners, especially you have officers like president, vice president, secretary, treasurer, have an employment agreement. Because again, we're trying to define the salary for subject to S corporation status. What is your salary? And also for standard employees. I want to point out the covenants not to compete have been severely curtailed in Washington. Really, because against public policy. Generally, the rule is that if you're making less than if your employee is making less than $100,000, you can't put in a covenant not to compete. They're making more than that. They're more like highly trained individuals, basically that have access to trade secrets. Really, then you can put in a covenant not to compete, but it's really restricted. Now, in the employment agreement, you can limit disclosure of confidential information. If you develop a particular formula, you have a client list. That you could require that information remain confidential during your employment and after employment. And should the employee leave, you can put in provisions that prevents efforts to poach clients or staff. That's a huge one. So especially if the employee had access to client records, you can put that in your employment agreement. Make sure that's in there. I also sometimes like to put in non-disparagement agreements, especially in our social media world. Really easy to post bad things against your current employer or former employer. Put provisions restricting that or eliminating that. You can't do that. Employee handbooks. As you get bigger, you might want to actually have a full-blown employee handbook for company policies. It can include social media usage, cell phone usage, lunch breaks, smoking, all the policies that you want to put in that apply to all the employees. And then what we want to do is tie that employee handbook into the employee agreement. So that way, if there's a violation of company policy, that could lead to termination under the employment agreement. Payroll. Make sure they hire a bookkeeper / accountant to set up payroll for your employees. That's easily to miss, but because when you hire an employee, you have to actually put in money into a trust account with the IRS as far as a withholding for tax purposes. You need to set up a payroll account with the IRS. So hire somebody, and you can have an office manager if they're good enough about it. I usually like to outsource that, in my case, to my CPA, which she does very, very well at. Lastly, the PBL formalities. Have meetings at least annually. PLCs, you're not, or LPs, you're not required to have meetings. But in my documents, I require them because, again, as part of the whole write stuff down. Make sure they have a record of what's going on. It may not be required, but it's good to have. And again, write everything down as it relates to company management. Very, very important. This.
And we're coming up to the latter part of the session here too, Chris.
Okay, I'm just going to wrap up with one thing. Buy-sell agreements, basically, A buy-sell agreement is basically the agreement between the owners as far as what happens if there's certain instance as far as death, disability, retirement. How does that soon-to-be former owners' shares or interests get transferred to other people? But what it does basically restricts transfers to outside third parties without the permission of the business or the other shareholders. What happens if there's a disability? How do you pay out? Because maybe that owner can't work for the company. They want to retire their shares. Give the company's right of first refusal. Issues as far as valuation, terms of payment. Also, make sure that if they're married, make sure you get a spousal consent. We are Washington is a community property state. While your spouse may not be licensed, they have an equity interest in your ownership. So make sure that the spouse consents to any restrictions on transfers and ownership. They agree to that. And lastly, again, and all right, let's try this. Exiting. Now, what happens when you want to get out? One, you just wind it down, just let it terminate. You're done. You wash your hands of it. You'll probably need to file a certificate of dissolution, and you may need to have a clear certificate with the Department of Revenue to notify, and also notify the IRS of the termination. Selling the PBLE, you want to sell to other owners, outside third parties. Just remember that the purchaser needs to be a licensed professional. Maybe you want to sell it to your employees. I've done that before. Business succession, bringing employees that are licensed in your juniors guys that are just starting out, but maybe want to bring them up and maybe make them potential owners. You can do an employee stock option plan, restricted stock grants, other deferred compensation plans, and eventually transfer ownership of the entity once you decide to retire to them. Lastly, estate plan. Make sure your PBLE is referenced in your will and powers of attorney. And make sure emphasize in your will that your stock has to be transferred to another licensed professional because your executor may not know that. And also designate who can operate the PBLE in your power of attorney if you're still alive but you're incapacitated. Who has the authority to act on your behalf? And that pretty much wraps up my presentation. I'm sorry, there's a lot of more information I can provide, but we're limited by time. But I will wrap it up here.
Okay, thanks, Chris. Actually, we do have a couple of questions that have accumulated in the chat, so I wanted to go through a couple of those if you've got time.
Yes.
All right. So one of the first ones is if a professional service company is set up and based in Switzerland, but the board of directors, who are also the ones who provide the company's services to the public, are based in the US, Scotland, and New Zealand, would the liability insurance need to be purchased in all 4 countries where the services are being rendered, or just Switzerland, or just the actual country where the services are being provided? Some of the services would occur in Australia, Germany, and other countries as well.
Oh, geez, that's kind of out there. I would assume, I'm definitely where the services are provided, and I would also assume that more likely than not that probably in the place where the entity was formed, as well. Switzerland, if it's formed there, I would assume that, because again, the entity itself needs to be covered as well, but also the locations where the services are provided. Now, again, that must make, again, the person must be licensed in the state of Washington or whichever state would actually perform those services. So we got that. So the yeah, that's without doing more research, that's kind of my gut reaction on that one. But most definitely where the services are provided, because the clients needed to have a recourse to go after you, where you perform the services.
All right, thank you, Chris. The next question is, can a PLLC provide services that don't require to be performed by a licensed professional in addition to the services the professional is licensed to provide?
No, except for one, pretty much they have to do that service, or at least they're, what in my description of the scope of services provided, I'd say that the directly related or ancillary to those services. They're not necessarily digging, for a dentist, not necessarily drilling into a person's teeth, but maybe services that maybe advertising, things like that, but that relate to the practice itself. Those are ancillary. That's fine. But other activities like investing in real estate. Oh, actually, I'm going to rephrase that. Maybe setting up ice cream business through your PLC, you can't do that. Now, state law does allow for, you can hold investments in your PLC. stocks, bonds, things like that. You're okay with that. That's one exception. But no, anything else, pretty much, as long as it's not tied to or ancillary to that profession, you can't do it.
All right. Thank you. So another question is the PLLC the name in the company only in the dentistry field? Is the PLLC the name in company only in the dentistry field?
Yes. Yes. So, example, if I was the dentist, it'd be Christopher T.L. Brown, EDS, PLLC. But no other, no, it's the only dentist, and I don't know why, because I think that maybe it's so invasive, maybe that because teeth are very, very sensitive. I don't know. That may have been some sort of knee-jerk reaction by some sort of legislator way back when. But that's the only industry that profession that requires that.
Okay. Okay, so I think this one might be a little bit more along a CPA bent, but I'll ask it anyway. Got a teacher here in the USA who's teaching overseas an online class.
Right.
Where should the teacher pay taxes, overseas or in the US?
Hey, can you repeat the question?
They are providing a service. Sorry.
It's not really to this presentation, but yeah, go ahead.
Yeah. They have a teacher that is in the US who is teaching overseas online classes. Where should the teacher pay taxes, overseas or in the USA?
Here.
Okay.
Because they're based here. So now, granted, that being said, wherever the classes are, say Switzerland, I'm going to use Switzerland. If they, Switzerland may actually impose a tax too. So that being said, then we get into tax treaty type of things. So basically, is there a tax treaty? You might be subject to double taxation technically, absent the application of tax treaty, which says that if you're paying taxes overseas, there's a tax credit on your U.S. taxes for that. That's usually the general rule, but that's basically the 30,000-foot level answer that I can give on that.
Yeah. And there is a comment from somebody at the end here that says, for international issues, many times expats can be helpful sources of information. I know that to be true.
Right, because I lived in Japan for 3.5 years, and so yeah, I had that issue come up, but the tax treaty kicked in. So in my case, because I was teaching over there.
Yeah.
Before becoming a lawyer, I taught English in Japan. So.
We have one last couple of questions here from Beth James. Do you have guidance about what title one should adopt as the owner of a small business with no employees? And I imagine they're referring to the initial.
Right. I mean, legally, for like, if you're a PLC, legally there's manager or member, and usually go manager on that one. Now, granted, there's nothing that's preclude you from saying, having the LLC say that, the manager shall be deemed to be the president, be called the president. You can do that. I mean, but it looks, at least in this ideal in the legal world, strictly on that. So it's weird to me. Not saying you can't do it. It's weird. So for professional service corporations, you cite as president. If you're the sole owner, you can say principal. I mean, technically, there's nothing on there. You can say owner. Not really happy with that, but from principal, you can say founder on that if you founded it. But for actually doing stuff, I mean, if you're signing a contract, it's definitely the president, because that's really a defined term under state law as far as who executes these things.
So for further clarification on that question, she is a nurse practitioner setting up a continuing education business for healthcare providers. She is the owner, no employees, set it up as a PLLC. Does that seem right? Doesn't seem. It was really hard to find help with this. That's what she said.
Well, technically, I mean, you can say the founder or principal of that. Usually I would say principal, because founder is kind of a dead term, really. A principal, that's more of a kind of global term as far as who has authority to do these things, although it's not legally defined. So in your operating documents, I say that the manager shall be referred to as the principal in your operating documents, so that we have that tie between the legal definition of who has authority to act on behalf of the LLC and the title. So,
hey, Chris, can you do me a favor real quick? Can you advance to the last slide? There's a lot of people asking for your information.
Oh, sure.
And then there was one last question. You know what? I'm going to skip that one and go straight back down to the bottom because so there was one question from here. It says, does Chris offer a new business package, say for reviewing operating agreements or any contracts, or is it always an hourly fee for business law consultations?
That's kind of a loaded question. I kind of have to, I mean, it's not really hourly. Usually after I kind of meet with the client, I can determine basically how much I think that my time is worth on that one. So unfortunately, it could be very, very narrow or very, very broad. And that's why I don't like to giving a kind of a package, because some people think that they're overpaying and some people may think that they're getting a great deal and all that. So it's more of a, like, we meet with me and we'll go over it type of thing. So yeah, I know that the area of law is basically going to more towards a fixed fee type of situation, but unfortunately, in my case, it really kind of depends on the client that I get. So it could be really easy, it could be really difficult. But then again, I try to, that my whole mantra or goal is really to make sure that it's whatever I charge is reasonable to both me and the client. So that way, because I'm looking more for return business. Because if the clients get mad at me for paying so many fees, they're not going to see me again. And I do other things, again, estate planning as well. So everybody needs estate planning. So
it is, I think, worth to note that you're not just an attorney. You're a very specialized attorney. You've got a lot of extensive training in some areas, and other areas you can still help people with some of the more simple topics, but there are some very advanced international law, for instance, or taxation law that Chris can also help with.
Right. So my background is basically I've been practicing for 21 years now, both in Oregon and Washington. I moved up from Oregon in 2007. I've been practicing since then here in Washington. I have a master's degree in tax law. So basically I deal with high-end complex estate planning, business formations, transactions. I have some international clients as well. So I'm not a generalist at all. I'm very, very niche. Which serves me well because I think that that's kind of an area of law that's kind of lacking in this area.
Yeah. Well, thank you so much, Chris. Did anybody else have any other questions for Chris while we've got him on the line? So for all those that are asking about the slides, we will be I'll be posting the video of this presentation on our YouTube channel, and you can access it through there. I do have one question from Jeanette here, and she's asking, is it essential to update a will with a brand new business or wait until it is profitable?
I would update it now, only because it's still business, still assets that you have. I mean, where does it go? I mean, profitability or not, I mean, your executor or person representative still needs to deal with it. So it's just basically just a bunch of assets that need to be disposed of. So it doesn't matter if it's profitable or not, they need to be taken care of.
Yeah, if you're doing anything, right, like you were saying, trying to put the assets into that bank account and really treat it as a business, then you're going to be creating something that yeah, like you said, profitable or not, needs to be dealt with.
Right, exactly. So, I mean, everybody has an estate. I mean, you may not think you have a whole lot, but your clothes are part of your estate. Your personal goods are part of your estate, so they need to be dealt with. That's why everybody needs an estate plan.
Awesome. Well, thank you so much, Chris. I really appreciate your time on this. I think there's been a wealth of information here, a lot to chew on. I think there's been a lot of stuff to review, and I think a lot of different situations that people are in right now that they're probably contemplating. So go ahead and make sure to take down Chris's information here. Like I said, he is local. He's in Olympia, it says right there. But yeah, thank you so much for joining us today on ScaleUp Mastermind, and we look forward to seeing you again soon. All right, have a great one, you guys. And thanks again, Chris.
All right, thank you.